Welcome to the Business SOS podcast. This is Rich Sierra. I'm the president of Florida Small Business Legal Center. I'm your host. This is episode 149 of our podcast as we continue our quest to episode 200. I got to plan some type of celebration for that. It's going to be very soon as we get closer to that number. Very excited about that. So I've been talking about the last few weeks about litigation, which, I'm a business litigator. I've been doing this for over 20 years now. And that's a big part of my practice, primarily working with business disputes. So I want to talk today about the topic is you got served, what to do in the first 48 hours after getting sued, after getting served. So if you are a defendant in a lawsuit, very likely you will learn about this lawsuit before you get served. And I'll explain why. There are law firms and companies that purchase the list from the courthouses that of anybody who was named a defendant in a lawsuit. And they do that for marketing purposes. They just download those lists, they buy them, they have a system already in place, been done this for years now, that they automatically have some letters printed and they do goes out every day. And it's part of getting some potential business for those people who got sued, especially with companies. If you're a owner of a business, which is most people that listen to my podcast, uh, you most likely you have a LLC, you have a corporation, sub S corp. Uh, your company, you will need to retain an attorney to represent you in that lawsuit unless it is a matter of small claims. So, for the purposes of our conversation, let's assume this is simply anything above county court that requires the company to be represented by counsel. Um, so what happens is that you get a letter from various law firms telling you are a defendant in this lawsuit. They explain, they put the case number there, uh, and they explain their services, and they tell you if you have an attorney, ignore this letter. Most likely, the envelope will have, which is required for those who send those letters, attorney, advertisement, so that way you don't think it's a demand letter. And you'll know, hey, I got this letter. Most likely, you'll get it before somebody serves you, and we'll explain that in a few minutes. Uh, so, in a case like that, so you get a letter like that, what you can do, you want to contact the law firm, you're welcome to. You're not obligated to, or you can contact an attorney of your choice. Uh, but that letter in and of itself that you receive from a solicitation does not obligate you to do anything. But what you can do is go straight to the court's website and do a search for the case, and you'll be able to pull the case up and see what the lawsuit is about and download it. So you'll be able to do that, and that's available pretty much in most jurisdictions. You can go online and get a copy of the lawsuit, download it to your PC. Uh, you still have not been served. Okay. So I'm not going to go into a deep dive of what is constitute service. That is a podcast in and of itself. There are a lot of nuances to service of process, but I'm going to give you kind of an overview, a big picture overview that what happens when you get served. So let me backtrack a second and talk about what is service of process and who are these process servers. As sometimes people hate them because they show up to your house and give you a copy of the lawsuit. Okay, let me talk about that first. Process servers have nothing to do with the case. In fact, that is the law. They're required to have nothing to do with the case. There are companies out there, a lot of them have private investigators, and they have a license by the state of Florida that they are authorized to provide service of process, get this lawsuit, and serve it personally to the defendant. That's their only job. Once they do that, they provide us what is called a return of service, and they said on this day, I served the defendant, John Smith, uh, this lawsuit, and he put a description of John Smith, and certified under oath that that was served. That's all this process server has to do. Then the process service company provides that return of service to us, and we file it with the court, stating that we filed the return of service. That's all that they have to do, and they have nothing to do with the case. We have nothing to do with the law firm. They're independent companies, so you don't have to be mean to them. They're simply doing a job, just handing you a piece of paper. That's so that's all they have to do. Okay. If somebody's trying to serve you with a lawsuit, in my opinion, there's no need to avoid service. That's my opinion. It is the responsibility of the law firm to get the information, obviously, to provide to the process server to serve you. And usually, there's a certain time limit to serve. In state court, it's 120 days. Federal court might be about the same, but there's from the time you file the lawsuit, there's a time limit where you have to serve the defendant. You cannot have it open indefinitely. If you cannot serve, we can ask for an extension. The court sometimes gives you 30 days, 60 days. It depends to serve a defendant. So they have a certain time period. The issue you have, if you're a business owner and you know you have a lawsuit and they're trying to serve you, sometimes they try to serve your place of business, say you're not there. They could provide that lawsuit to the employee, okay, to somebody in that office to provide the lawsuit to you, and that could constitute accept a proper service. So it's different with a business. If you're a business owner in Florida and you have to have a registered agent, in a registered agent, you need to have somebody physically available, I believe it's between 10 and 2 p.m., 10 a.m. 2 p.m., to accept service or process of any type of lawsuit that you receive, or any type of legal paper. If some people put themselves as registered agents, they're not available. In that case, you can be served to the Secretary of State. So you don't want that to happen, because then Secretary of State accepts service, you don't know about it, you can get defaulted. So if you get a call from a process server telling you, we have some documents to provide to you, just accept them, and then we'll deal with it. Okay, so that was a very brief overview of process service. We'll talk about that. In fact, I'll do maybe another podcast focusing on what constitutes personal service and go a little bit more into the statute. But for the purposes of today's podcast, I want to talk about what not to do when you get served. Those 48 hours are very important. And there are a lot of people make tremendous mistakes. Those 24 to 48 hours after they receive the lawsuit, that can be avoidable. And then after they make the mistakes, that's when they decide to call an attorney, and we have to kind of undo the problem. And we have talked about these mistakes before. Some of them might be repeated, but some of them might be new. So let's talk about that. Okay. The first rule that I tell you, that if you are the recipient of a lawsuit, you're a defendant in the lawsuit, is do not panic. Okay, do not panic, and also don't ignore it. You will get a little bit high blood pressure. You're going to have some anxiety. It's not fun to be a defendant in the lawsuit. It's stressful. It's understandable. Most likely, when the lawsuit comes in, you're not going to be surprised. Okay, it's not going to come out of the blue. For the most part, you might have received a demand letter from someone. You might have some email communication about the dispute that arose that perhaps did not get resolved prior to this lawsuit being filed. So the lawsuit should not be a surprise to you for the most part. Okay, especially if it deals with something related to a contract or a business. There's usually some pre-suit communication that takes place before the lawsuit is filed. So the lawsuit comes in, most likely will not be a surprise to you. You're surprised that it actually got filed, but not the facts, and the party who's suing you will now be a surprise. So the first thing to do is, not to do, is go ahead and start calling the other party and start, yelling on the phone, said, "What the hell do you do?" And why are you suing me? Uh, and or send a nasty text message to the other side in anger, or call the attorney and start negotiating with the attorney. Don't do any of those. You know, the what you have to do in this case is get an attorney. Okay. Obviously, read the lawsuit. If you have to put it out the next morning, that's fine. But you have to read the lawsuit, read the facts, understand why you're getting sued. And if you do not understand it, an attorney will be able to help you with that. Okay. Also, don't ignore it, or don't delay getting an attorney. I'll give you an example. It happened, a few years ago. Okay. Uh, your client, contact my office. He got sued. He had good defenses. Okay. He waited too long to retain us. Okay. And then he got a default, clerk's default, because he waited too long. After the clerk's default, he retained our services shortly thereafter. Okay. So in that case, we had it took a little longer time, because what we had to do is get that reversed, get a motion to set aside a default. It was not a default final judgment, and we were able to get it reversed, and then continue the case moving forward. But if the client would have retained us within that time period when the lawsuit was, you have that window to respond to the lawsuit, say it's 20 days, we can file something on the 20th day, you still don't get defaulted. So waiting too long is just not helpful. But also costs more money, because we have to file this motion to vacate the default. And if the other side is not in agreement that it should not be vacated to an agreed order, then we need to go to the judge and explain to the judge that there was some excusable neglect, and why the response was not filed, that the client acted diligently in retaining counsel, and there's a meritorious defense to the lawsuit, and we want to move forward. In Florida, Florida's courts would like to adjudicate cases on the merits. The default final judgments or default should be something at the last resort if it looks like the defendant does not participate in the proceedings and ignores them. So ignoring the lawsuit and ignoring and taking too long to act, or procrastinating, is not going to be helpful to you. So it is important to go ahead and act quickly when you receive it, and not wait too long. But you have some time, but you don't have a limited time. There's a time factor here, and court deadlines are very important. And there's a reason for those court deadlines, is to move the case forward and to have some closure to that process, to the case. And some jurisdictions, I know Palm Beach does, and maybe in the West Coast of Florida as well, they give you what is called a case management order along with the complaint and the summons. Okay, let me tell you what you will receive when you receive the lawsuit. You'll receive a summons that tell you instructions where to respond to this lawsuit and how. You receive the complaint, which is the lawsuit. Those two things you need to receive. You receive the summons along without the complaint. There's a problem with the complaint. Without the summons, a problem. Your attorney will ask you, what did you receive when you were served? So that's the analysis that we do to make sure that was proper service. You also may receive something called a case management order. And what it does, it gives you kind of a list of deadlines based on the filing of the case that will have to be met. And they're not specific dates per se, but it kind of tells you, okay, this case is projected to go to trial, 24 months from the date of filing. That gives you an idea. And it works backwards. The service of the complaint has to be served within 120 days. You've already been served, so that deadline has passed. There's a deadline to when to add additional parties, could be maybe 90 days or 120 days from there. So there are deadlines that have to be met. Discovery closes perhaps maybe 90 days before the trial date. Mediation has to be completed perhaps 120 days before the trial date. So that gives you an idea. So there are a lot of deadlines that the attorneys immediately have to put in the calendar to begin the process. So you'll receive that's what is called a case management order. You may not receive it with your lawsuit, but it might be there. Now, why contacting the plaintiff is not a good idea. And a lot of people try to do this. They try to negotiate things on their own. They try to make admissions or text messages, and if you're going to negotiate anything with your posting site after a lawsuit has been filed, my recommendation is to get a lawyer to do it for you. And I'll tell you why. If you start communicating and start sending text messages back and forth, then you have a situation where all those text messages can be considered admissible evidence into a trial. When an attorney does it, might be considered confidential settlement communication. We immediately create that when we talk about settlements in our emails. We say this is confidential settlement communication. What that means is that whatever we say to each other under that umbrella of the confidential settlement communication cannot be used in any court proceeding. And this is important. So let me repeat it again. When we state that what we're discussing here, whether it's by phone or by email, you should not discuss things via text, but anyway, via email, we send offers, counter offers. We say this is confidential settlement communication. What it means, it cannot be used in a court proceeding as any type of admission or liability. And it creates that cone of silence, if you will, that you don't have, that you can speak freely about the case. That's why you want an attorney doing it and not you. For a lot of different reasons. We're more objective, we're professionals, this is what we're trained to do. You're not. Also, when it is your case, you're emotionally invested. You want to have some separation and have somebody else do it on your behalf. It's a lot better for you. You also don't want to talk to the attorney other than to say, I'm getting a lawyer. That's basically very limited communication. And it might be better in writing, said, I got the lawsuit. Can I get an extension? I'm getting an attorney, something like that. But I've had situations where the client, before retaining me, has engaged already in exchange of the documents with the plaintiff, mostly voluntarily providing documents to plaintiff's counsel or trying to engage in negotiations with plaintiff counsel. And then they don't go his way, and then that's why they call me, say, oh, I want you to finish this negotiation. I'm like, you should have never started in the first place. Well, I gave him my bank statements, and he didn't he didn't want to agree to a settlement. My response would be, why in the world did you give your bank statements in the first place? Well, he asked for them. Asked for a lot of things. Okay. The point is this: if you have an attorney on the other side, you're not an attorney, you will be outmatched. You have to have an attorney on your side to level the playing field. An attorney who knows litigation, who knows how to negotiate, to level the playing field. You should not do this yourself. Something else that people do, and it's not a good idea, is to send a letter to the judge. Other than to file a paper to ask for an extension of time, to seek counsel, and to respond to the lawsuit. And I want you to respond, and I want to use that word very clearly, and I'll tell you why in a second. Other than just filing a piece of paper with the court clerk saying, I need more time to get a lawyer, nothing else. I've seen situations where the client, they're so upset, so angry, rightly so, that they received this lawsuit and they believe that it's unfair. And I have not had anyone in 21 years say, I got this lawsuit. I think the lawsuit is good. It was fair for them to sue me. It won't happen. Okay. So it is fair to say that most people believe the lawsuit is unfair and it is unjustified. And it is right to be angry at that. But the solution is not for you to sit down in your computer and start writing all this narrative about the case, put exhibits together, attachments, copies of checks, and just this nice package and send it to the judge and to the clerk and file it as your defenses. It's just not a good idea to do that. Number one, if you're a corporate client, if you have a corporation or a business, that will be stricken because for Florida law, you must have counsel representing you in court. There's not an exception to that. The only exception is small claims that we talked about that before, but not anything above small claims. You need to have an attorney. So not only all the effort you spent will be wasted because that particular document that you provided will be considered a nullity, you have already voluntarily provided discovery to plaintiff's counsel. Discovery that maybe you did not have to provide. You certainly didn't have to write a narrative about the case. You certainly didn't have to volunteer any type of information about the case unless you're in a deposition and when you're asked to provide it. And you're making also your future attorney's life more difficult. And when you do that, it'll be more expensive for you. So in that case, just don't do that. If you want to write something for and don't send it to the court, that's fine. You can write all you want, you can type it, you can put together a packet for your future lawyer. That is okay. You have not sent it to anyone, and that's fine. But don't send it to the judge. The judge, number one, is not going to read it. Judges have hundreds of cases, and they only look at documents when there's a hearing or there's a trial because they already have a system and a schedule. So whatever you send to the judge, it's not going to be read. It's not waiting for your case. You're not the only case. Number two, that's not the process. You do not understand the process. Attorneys do. One of the things that sometimes people do, which is not a good idea, is to post the information in social media or say, I've been sued by so-and-so, here's the lawsuit, or start making comments in social media about the lawsuit and how unfair it is, or you start making negative statements, disparaging statements about the plaintiff. It's not a good idea to do that. I'll tell you why. Anything you say within the litigation context, any responses that are made within the litigation context, they have immunity, meaning that it's all with part of the litigation process. But anything you say outside of the litigation process, you start posting disparaging remarks against the plaintiff about the plaintiff in social media, that is not protected communication. That is not subject to any type of immunity. Then you might have a potential defamation claim as well, on top of whatever claims are in that lawsuit. So I don't recommend you posting anything in social media, even that you were sued, nothing. You can talk about it with your spouse. You have marital communication privilege, so nobody can ask your spouse, what do you guys talk about? That's not going to happen. That should not happen. And the attorneys will object to that anyway. You can talk to your attorney, but nobody else. Now, what people also do is that they know a friend, a colleague, and they begin to talk to that colleague or friend who's not an attorney about the case. They share the lawsuit, they talk details about the dispute, they start exchanging the text, they want their opinion. And I've had that before. So I talked to my friend, neighbor, he's I get his advice often, and he told me about the lawsuit, and I'm like, is he a lawyer? No. So why are you talking to him about that? Because what happened is this: one of the questions that we ask in our discovery is to provide the name and address and phone numbers and email addresses of anyone else besides your attorney and your spouse that you discussed this lawsuit with. So whomever you spoke with about this lawsuit, now your spouse or your attorney, that person can be deposed about what you said. In any statements you said, any text messages you said, all the email communication, all that can be discoverable. And it's an admission by a party opponent, which is you. So this is a private matter, so you don't want to start sharing this information to anybody else, other those that on a need-to-know basis. It is for your protection. Now, it's important for you to know what are you being sued and what they're seeking. You will see in the first two lines of the lawsuit, this is a complaint for damages which exceed $50,000, excluding attorney's fees and costs. And you think you're being sued for $50,000. We have to write in our complaints the jurisdictional amount of the lawsuit, meaning that in order for the court to accept the case or to have jurisdiction, they have to meet a minimum threshold. In Florida, is $50,000. So we have to say that this lawsuit, has a minimum jurisdictional amount of $50,000 more. Otherwise, it does not belong there. So you're not being sued for $50,000, you're being sued for more. Sometimes in the damages section in the wherefore clause of the lawsuit said they're seeking damages of X number of dollars. The damages are usually calculated much later. So it's important for you to understand what the lawsuit is all about. Are they looking for an injunction? Are they looking for specific performance? What are they looking for? A lawsuit is a legal document most likely prepared by an attorney. Your best bet is to have an attorney go over the lawsuit with you, explain to you what the lawsuit is, what the claims are. It could be breach of contract. If it's some type of business dispute, most likely you have a breach of contract claim. Sometimes, in whether or not, you have to find out whether you individually are being sued as an individual and why. Sometimes you have situations where the company is being sued, but the owner is being sued as well. And there are defenses for that. Whether you've been sued for fraudulent misrepresentation, negligent misrepresentation. There are a lot of different theories that we have of law to recovery that we can include in a lawsuit. Understand those. And it's important for you to discuss that with the attorney as well and have an understanding what exactly they're seeking. Now, you got to find out whether the lawsuit is federal or state court. You'll know that right from the beginning. If it says in the circuit court of the 15th Judicial Circuit, that's Palm Beach County, and for Palm Beach County, Florida, that's county court. If you see United States District Court, Southern District of Florida, for example, that's federal court. So you got to understand which court. Again, your objective is to get an attorney, not to do this yourself. Those first 48 hours are very important. What you do when you meet your attorney the first time, for that first meeting, okay? I think it's important that understand the deadlines, understand why you're being sued. The attorney will review the summons of the complaint. they will identify. The first thing will ask you, when were you served, and that's when somebody emails or calls and said, "I got this lawsuit. We'll try to get the information." Said, "When were you served?" That's the first deadline that we look for, and that deadline we know we have 20 days, and so we know how critical it is for that meeting to happen immediately, or it can wait a few days. So that's the first deadline we have to look at. And you have to understanding now. Sometimes people get served and they're not there, but I'll tell you what the process server does. Say you're the server of your house and you're not there, but your son is there. Your son is over 15 years old. He can accept service on your behalf. They'll serve him on your behalf. It's not, and they'll write it down. So sometimes if you're not there, but in the summons, they usually write the date and the time that you were served. It's handwritten. So that kind of, you can tell the attorney, this is what they have written. I got this 2 days ago. I was on vacation, whatever the case may be. But that date is important. If not, we'll try to look it up on the return of service that they file. One thing you have to do is when you get served with a lawsuit, you got to preserve all the emails, all the evidence, anything related to this case, you have to preserve. So litigation hold, meaning don't delete any text messages, even if they're embarrassing. Don't delete anything. That could be worse for you. Your attorney can decide how to handle that piece of information, but those deletions, we can find out whether you deleted information or not. So the attorneys can find out. So don't delete anything, preserve all the evidence, anything related to the case, all documents, emails, text messages, you have to preserve them. It's very important. If you have insurance, notify your insurance carrier immediately. A lot of people call me and say, "I got sued." I said, "Do you have general liability insurance? Do you have?" Say, "Yes." Well, contact your carrier, let them know as soon as possible. The lawsuit may or may not be covered, but it's important to notify your carrier, and then the carrier will tell you whether or not it is covered, and they'll send you a letter to that effect. And when you call your carrier, it is important to get a claim number, and they give you a written communication. They received a claim, and they'll tell you one way or the other in writing whether or not it will be accepted or not. But your attorney can tell you that. But it's important to contact your carrier and provide the information and get a claim in. I think what I'm going to do here, I want to recap this. I think I'm going over the time limit that I had for this podcast, but I think I went over the other highlights that I want to talk to you about today. One more thing. Don't clean up your social media after you get served. They'll find that out. In fact, by the time that you were served with the lawsuit, they'll probably have copies of all your social media postings. So deleting them will be useless. So just preserve everything. So that way you don't have any issues about spoliation of evidence, which could have severe sanctions. So let me recap here. 5 steps within the first 48 hours. Number 1, don't panic. Don't panic, but don't ignore it. Know the date of service and count 20 days after that. So that way you know when that is due. Now, don't wait for the 19th day to contact that attorney. Do it sooner than that so the attorney has time to prepare and not deal with a time crunch of 1 day to respond, which inevitably is basically asking for an extension of time. So be diligent on that. Read the lawsuit. Understand what the lawsuit is all about, so you can explain it to the attorney. In terms of the facts, the claims, the attorney will understand, but at least the facts, just read them to find out and highlight items you want to talk to your attorney about. 3, contact your attorney immediately. It is so imperative that you contact an attorney if you get served with a lawsuit. Don't do this yourself. Don't contact the court. Don't contact opposing counsel. Don't start sending letters to the judge. Contact an attorney immediately for the attorney to help you navigate these waters, this challenge that you're facing. Notify your insurance carrier. Submit a claim if it's appropriate. because the policy may cover the defense of the lawsuit. And there are two parts. You have the defense and you have the claim. There might be a duty to defend the claim, although they might not cover the claim itself. So it is important to at least notify your insurance carrier, so at least perhaps you might have coverage. 5, preserve everything. It is important for you to preserve all the documents, the emails, or the text messages regarding the matter, because they will be requested at discovery. So if you delete some of those, you might have an issue with spoliation of evidence, and you might have an issue with sanctions. So it's not including striking the pleadings if it looks like this was done intentionally for the purposes of, harming the litigation or preventing to the side to having access to the documents. So it is not worth doing it. Even if it's embarrassing, your attorney will handle it. This is good for today. If you have any questions about any of the topics that I talked to today or anything else, my email is rich@richsierra.com. My number is 866-842-5202. Our website is floridasmallbusinesslegalcenter.com. If you want to watch this video on our YouTube channel, it's youtube.com/@RichardSierra. Remember, check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra, and my goal is to help you succeed.